Get ready for the dictation. Start. The intent is that authority to complete acquisition within 5 years. The legislature frowns upon delay of more than 5 years. In case it is held in spite of refusal to receive payment, it is necessary to deposit in court. Most of the acquisition would lapse. The acquisition of Raisina Hills in Lutyens zone of Delhi, made in 1913, was questioned in said case, but this court never intended such misuse of the provision. There is no dearth of ingenuity left in misusing the provisions of Section 24 of the 2013 Act, whereas it is meant to beneficial legislation. Its intention is to resettle the incumbents to offer better compensation as compared to the 1894 Act. In the various ways the provision has been sought to be blatantly misused, the law never envisages such absurd results as is being sought to be achieved. The beneficial provisions of 2013 Act are put to misuse that tantamounts to grossest abuse of the provisions of law to reopen such acquisitions, and court has to thwart all such attempts at threshold and not to receive such cases even for consideration for a moment. We see development has taken place in the area that has been acquired. There have been several rounds of litigation which have been lost by landowners even up to this court. Thereafter, some persons are filing cases on the basis of power of attorneys or sale deeds which are not permissible after land has vested in the state, and purchase after issuance of notification under Section 4 is illegal and void, and no such right is given to such incumbents to reopen the whole gamut of issues and to even contend that acquisition has lapsed under the provisions of the 2013 Act. The law as prevailed under the Act of 1894 never invalidated any land acquisition in the absence of amount being deposited in court since the time immemorial. In most cases where reference is not sought, amount had been invariably deposited in the treasury as provided in statutory rules framed under Section 55 of Act of 1894 and other standing order issued by state governments, and there were decisions of this court which have simply laid down that in case landowner is not responsible for delay in payment, at the most he may be entitled to interest on such amount in case it has not been tendered oblique paid to him when possession has been taken. Similar provisions are made under sections 77 and 80 of the Act of 2013. All of a sudden, it would not be appropriate, considering the statutory rules which have been framed under Section 55 of the Act of 1894, and order to invalidate all such land acquisitions which have taken place in various states in the country by laying down that once amount has not been deposited in the court but in treasury, acquisitions would lapse under Section 24. It will be a very harsh operation of law, as old Act never provided for such a consequence since 1894. the act was enacted till new 2013 act came into force. Same is not consequence in case acquisition is made under Act of 2013 is apparent from conjoint reading of sections 77 and 80 thereof. When there were such anomalous situation, the statutory rules and statutory orders issued by various state governments dealing how the government money has to be dealt with, it would not be appropriate to unsettle the legal position. The 1894 Act never contemplated such a result, and by and large it was not the practice to deposit in court. Only in those cases the amount used to be deposited in court where reference was sought under sections 18 or 30 was provided under rules also, and there was dispute as to person entitled to it or apportionment thereof between the claimants. Stop.